Rahul, really appreciate your time. Maharashtra Chief Minister Eknath Shinde's faction is the real Shiv Sena, is what you have pronounced. But your critics are saying, Mr. Narwekar, that your judgment is on expected lines and you were looking at ways to justify defection.
Well, I have no reason to answer baseless allegations. I have passed an order which is completely sustainable in law. There is no, it is a justified order. I have given a reasoning to every observation or conclusion that I have reached to. And therefore, if someone has a problem with this or believes that this is untenable in law or believes that this is not justified, you should ask them what is the reasoning. I have delivered an order. I've spoken about it, read it out for almost 2 hours. I have passed an in detail order. So kindly bring out the lacuna or perhaps the shortfalls, shortcomings of that order and then make such baseless allegations.
Okay, Mr. Narwekar, if Shinde camp is the real Shiv Sena, is what you have said, and Bharat Gogavle is the whip, in that case, Uddhav Thackeray camp MLAs defied the whip. Then why no disqualification is the question that is being asked?
See, the courts have primarily asked me to decide which is the original political party, because the whip of the original political party would be applicable and should be recognized. That's what the court had said. So after recognizing Mr. Bharat Gogavle as the whip of the Shiv Sena political party, I was further to ensure that the whip which was issued by Bharat Gogavle has been adequately and properly served on the MLAs belonging to the Thackeray faction. It appears that this service was not complete. There was no proof or evidence to show that this whip was properly served upon the members the MLAs belonging to the Thackeray faction. And therefore, since this filter was not cleared, it was not appropriate for me, under the principles of natural justice, to hold that the MLAs of the Thackeray faction should be held disqualified. So, I have mentioned all this in my order. Despite that, if, the same questions are going to be put, it's going to be, you can awaken a person who is sleeping, but it's rather impossible to wake up a person who is pretending to sleep.
My last question to you, you have held that non-attendance of party meeting is not a ground to attract disqualification under 10th schedule, as it's merely an act of dissent. But many in the past have been disqualified merely for skipping party meetings. So this is a new reading of that, that schedule.
See, if you read the concluding paragraphs of my order, I have very well narrated in that as to how the 10th schedule and the Speaker's office should not be used as a weapon to destroy inter-party dissent. You have to appreciate that the Schedule 10, the Speaker is only mandated to ensure that defection doesn't happen. But mere non-attendance of a meeting does not amount to voluntarily giving up the membership of your party. Not attending a meeting can at best be termed as dissent which is being voiced by a group within the party. I've explained that in my order. And you should also remember and recognize that, the order which you are talking about with regards to there being several orders where non-attending meeting has been held to be, that's not true. There's one order of Shriman Bahasab Patil versus in the Karnataka Assembly, where it was not just the non-attendance of the meeting, it was coupled with non-attendance of the assembly session. So there was a grave irregularity which could have been inferred to be voluntarily giving up of membership. In the present case, I have applied my mind to the facts of this case, and I am convinced that mere non-attendance of meeting cannot and should not be allowed to interpret as voluntarily giving up membership of the party, and this would be in breach of the basic fundamental rights of an individual, the right to dissent, which is also considered as a right under the freedom of speech under Article 14, 19, 21. So I've explained myself very well in my order, and I'm sure a basic perusal of that order will clear all these doubts.
A Thackeray camp, Mr. Narwekar, has complained against you to the Supreme Court through an affidavit about your meeting with Chief Minister Eknath Shinde. How do you justify that?
See, you have to understand that while I'm adjudicating petitions pertaining to disqualification, which have been going on for almost a year now, I am not precluded or barred from dispensing with my other responsibilities. I am the head of the legislature board, of which the chief minister is also a member. I have to meet him almost every 15 days to a month to discuss various issues pertaining to the board. I'm a MLA of a constituency. I have to discharge my duties towards my constituents, for which I need to seek the indulgence of the government. And being the head of the executive, I definitely have to meet the chief minister for that. I've already explained the reasons why I had met the chief minister. I was to meet him on the 3rd of January because of ill health. I had got influenza. I could not meet him. After I recovered, I sought his time to discuss some important issues. And let me tell you that in the past 1 year, there are several MLAs belonging to the Shiv Sena against whom disqualification petitions were pending. They have come and met me in my chamber and met me otherwise. Does that mean that I had something else to discuss with them? I went to meet the chief minister in broad daylight. I have met him after an official engagement was sought. I have gone in my official vehicle. I have not hidden and gone in the stroke of midnight or in the dark. So, casting such aspersions and insinuations on a constitutional position is very unfair, uncalled for, and needless to state that it is completely in disregard to a constitutional institution which I head.
All right, Rahul Narwekar, Speaker of the Maharashtra Assembly, the man of the moment. Thank you so much for speaking to NDTV.